We'll begin the webinar now. Welcome to this Legal Aid New South Wales Law Week webinar. Not navigating the system, divorce and separation. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. To start with, I would like to acknowledge the traditional owners of the land from which we are broadcasting today. For me, that is the Widjabul Waiable people of the Bundjalung Nation. I would also like to pay my respects to the elders, both past and present, and extend that respect to any Aboriginal or Torres Strait Islander people joining this webinar this afternoon. Your presenter today is Florence Cruz Montalvo, a solicitor with Legal Aid's Refugee Service. Florence, I'll hand over to you now. Thank you.
Thank you so much, Bridget, and thank you for joining us, everyone. Like Bridget said, my name is Florence and I'm a solicitor with the Refugee Service of Legal Aid New South Wales. Now, the Refugee Service is a specialist service of legal aid that provides recently arrived refugees with free and confidential legal advice and assistance on issues across different areas of law. And today's session is part of a suite of legal webinars from the Refugee Service, delivering as part of Law Week to community workers, volunteers and frontline workers that support clients from refugee backgrounds. The webinars are on common legal issues that face newly arrived refugees. And today's session is on divorce and separation. And we'll be looking at, firstly, the legal requirements to be eligible for divorce in Australia. During that segment, I will discuss common issues faced by refugee clients when applying for divorce with a short Q&A. Next, we'll focus on clients who are the respondents to a divorce application and frequently asked questions that come up on these matters. We will again have time for a short Q&A before moving on to practical issues in divorce proceedings, followed by practical issues faced by recently separated clients. And that will transition us into our discussion about how you can support your clients who are going through this process. And then we'll have some extra time for any final questions at the end. So hopefully by the end of the session, you will have further developed your knowledge of the legal requirements to be eligible for divorce, increased your understanding of the general divorce process, built your confidence and ability to identify legal issues faced by clients. As frontline staff and persons who work closely with clients, you're in the best possible position to help clients get legal advice and support as soon as possible. And lastly, I hope you will leave this session thinking about your own work and role and how you can implement some of your learnings or reaffirmed concepts from today to support our collective clients. Now, before I go through the legal requirements to be eligible to apply for divorce in Australia, I wanted to open it up to everyone to have a go at our first question. It's a multiple choice question about the grounds for divorce in Australia. So we're
going to launch a poll. Sorry, Florence, I just thought I'd let the audience know I'm going to launch a poll so they can actually click on the screen and choose their answer.
Brilliant, thank you, Bridget. Okay, so the question is, to apply for divorce in Australia, you must prove that the marriage has broken down irretrievably. To prove that a marriage has broken down irretrievably, you must satisfy the court that A, your spouse has committed adultery, B, your spouse has abandoned you, B, your spouse has engaged in unreasonable behaviour, D, you and your spouse have been separated for at least 12 months, or E, any of the above circumstances have occurred.
People are responding. I'll just give them a little bit more time to finish answering. Okay, I'll close the poll off now and we'll share the responses.
Perfect. Yep, so I'm glad to see that 54% of you say you and your spouse have been separated for at least 12 months. And 46%, any of the above circumstances have occurred. And I think the reason why so many people think it's that is because, you know, that's the case in a lot of other countries. But the answer is D. So spouses must have been separated for at least 12 months. So Yay to everyone who said C. In Australia, we have a no-fault divorce system. And that means that the court does not need to know why the marriage has broken down. They simply need to be satisfied that the spouses have been separated for at least 12 months and that there's no prospects of the spouses reconciling for the court to find that the marriage has broken down irretrievably. Okay, so let's run another poll, Bridget. Thank you.
Yeah.
The next question, this is a true or false question. So a spouse who files a sole application for divorce can apply for an exemption to the 12-month separation period requirement if there is a history of family violence. True or false? What are we thinking?
Okay, people are responding now. All right, I'll close the poll. It looks like everyone's answered now, I think. So
Yeah.
I'll close the
What do you think?
poll off and share the responses.
Awesome. Yes, and the answer is false. So there are no exemptions to the 12-month separation period or options to expedite this time. So the separation period, it's what satisfies the court that the marriage has broken down and that it's not likely that the spouses will reconcile. Okay, so let's look at this concept of separation. Sometimes when clients speak to me, they're a bit confused about the difference between a separation and a divorce. So separation is the term we use to refer to the end of the relationship, whereas divorce refers to when the marriage legally ends. The date of separation is it's a legal term that has legal meaning, and it refers to the date one of the spouses considered the relationship to be over and in some way communicated that to the other spouse. For example, through a conversation where they clearly stated they wanted to separate or get a divorce, or through actions such as sleeping in a separate bedroom and no longer having a husband and wife intimate relationship or moving out altogether. The 12-month separation period starts from the date of separation, regardless of whether the parties have physically separated or not. So spouses who have ended their relationship but continue to live at the same property are likely to be considered separated under the same roof if they can prove that they are living separately and apart. And separation under the same roof, it's a common occurrence that I see when dealing
Florence, I think we've
in
lost
these
the sound.
situations where the spouses have been separated under the same roof, further evidence is required when they apply for divorce to prove that their marriage has broken down irretrievably. So this further evidence is an affidavit, which is a written statement sworn or affirmed by the person making the statement and filed with the court. The client must show that they have lived separately and apart from their spouses, as opposed to simply being in a bad marriage while living at the same address. Now, if spouses are applying together, then they need to prepare separate affidavits. If only one spouse has applied for divorce, then they need to prepare an affidavit and have a third party, like a friend or a relative, prepare a supporting affidavit. This third party should be someone who knows about the separation and preferably someone who has been aware of the separation under the same roof since the parties separated or shortly after. So the 12-month separation period is the first eligibility requirement I ask about when I speak to clients who want advice on applying for divorce. The next question I ask my clients is the date they arrived in Australia. Now, you don't have to be an Australian citizen to apply for divorce, but you do have to meet the jurisdictional requirement, which looks at the applicant's residence in Australia. And this is a common issue that arises for refugee clients who want to apply for divorce shortly after arriving in Australia. For non-citizens to be eligible for divorce, they must have lived in Australia for at least 12 months immediately before applying for divorce. Now, sometimes clients think that they can just get divorced overseas, usually by traveling to the country they had been living in immediately before coming to Australia, where it might be a faster process. And that way they don't have to wait the 12-month residence period or any other requirement. Now, clients should get legal advice before applying for divorce overseas because there are strict rules on the recognition of foreign divorces, and not all divorces made overseas are legally recognised in Australia. Okay, so the third question I ask clients is, do you have a copy of your marriage certificate, and is it in English? Because applicants need to prove that they have a valid marriage to apply for divorce. Now, most clients we see were married before they came to Australia, and a common question I'm asked is whether their foreign marriage is valid in Australia. Almost always the answer is yes, and this is because if the marriage was recognised and valid in the country where the marriage ceremony took place, then it will automatically be recognised in Australia. There are a few exceptions to this. So if you have a client you're not sure has a valid marriage, it's best to refer them for legal advice before lodging an application. The other common issue I see are situations where a client got married while they were in a refugee camp. Their marriage was not registered and they have no marriage certificate. Often these marriages will still be recognised in Australia, so the client will still need to apply for divorce before they can remarry. And in these situations, the client must provide an affidavit at the time they apply for divorce, setting out the circumstances around their marriage ceremony. The last issue that commonly arises with marriage certificates, particularly with Arabic, Farsi or Dari speaking clients, is the spelling of their names on the marriage certificate. Because of the different language script, it's common for names to be misspelt and appear differently in translated marriage certificates to the client's Australian identity document. And the way to address this issue is by preparing a brief affidavit explaining the name on the marriage certificate is incorrect and confirming the correct spelling of the name. The next requirement only applies where there are children of the marriage that are under the age of 18 or children who were treated as children of the marriage who are under the age of 18, such as stepchildren. Now, there must be appropriate arrangements in place for the care and welfare of the children. The divorce application includes a part that asks about the care arrangements for the children, their health, education, and financial support. It's important for clients to understand that even though the application is asking about the arrangements for the children, the court will not make any orders about the children during the divorce proceedings. This is because it is a separate issue and a separate application must be made to the court for the court to make parenting orders. And for this reason, the court can still proceed with the divorce and grant the order even if they are not satisfied that there are proper arrangements in place for the children. And the last requirement is service. And this requirement only applies where a client makes a sole application for divorce. So service is the legal term for the process of giving an official court copy of the filed documents onto the other party, onto the other spouse in this situation. The purpose for this is so the other party is aware of the proceedings and for them to have an opportunity to respond to the application if necessary. The service requirement still applies even if the other spouse lives overseas and has never entered Australia. But there are different rules if the spouse lives overseas, depending on which country they live in. So clients should be referred for legal advice on this issue if it applies to them. If the other spouse lives in Australia, then there are two ways that a client can serve their spouse. The first is by post. And this is a good method if the other spouse is likely to acknowledge they have received the documents by signing and returning the acknowledgement form. The second is by hand. And this is where a third party over the age of 18 hand delivers the documents to the spouse. And it's often the best method because if the spouse refuses to take the documents, the person trying to serve the spouse just needs to tell them what the documents are. So this is the application for divorce by X, the date of the divorce hearing, and leave the documents on the ground at the spouse's feet. So when a person applies for divorce, they must write the address for service of their spouse on the application. This is often their spouse's home address, but it can be a PO box or an alternate address for their spouse. If they're, an address that they're willing and able to receive documents at, such as a workplace, a friend's or relative's house, or even the office of an organisation they're engaged with. So it's important for clients to think about service before they even apply for divorce. And there are two common issues I see come up with the service requirement. The first issue is not knowing where the spouse currently lives. Now, after spouses separate, understandably, they don't want to communicate anymore. And by the time the 12-month separation period passes, they no longer have any contact details for their spouse, or sometimes they just have a contact number for them. Other times, clients separated before they came to Australia. They arrived in Australia alone, and they don't know where their spouse is located. In either of these situations, clients can apply to the court for permission to send their divorce documents to their spouse in a way other than by hand or by post. And I've helped clients ask for permission to serve their documents by email, WhatsApp message, private Facebook message, or even posting the documents to a relative their spouse still had regular contact with. To be granted the permission, clients need to make all reasonable attempts to find their spouse, to find their address, their spouse's address, or a way of reaching them before they can apply to the court. If there are safety concerns around contacting the other spouse, or there is a no contact AVO in place, it's best to refer clients for legal advice before they make any attempts to serve their spouse. The second common issue I see with service are clients whose spouses are missing persons overseas. I've had several clients who have come to Australia alone. Their spouse has been missing for years, presumed dead, but no death certificate has been issued because the laws in the other country don't allow the issuing of the certificate in those circumstances. Now, in these cases, the client can ask the court to waive the requirement of having to serve their spouse, and they must file evidence that their spouse is a missing person in support of their application. Okay, so to recap, the legal requirements to apply for divorce in Australia are, number one, a valid marriage, which is proven by providing a copy of the marriage certificate and its English translation, or an affidavit in lieu of the marriage certificate. Two, an irretrievable breakdown of the marriage, and that's proven by at least 12 months of separation. Further evidence is required if the spouses have been separated under the same roof. If the marriage is less than 2 years, then a couples counselling certificate is required, or an affidavit explaining why counselling is not appropriate. The third requirement is that the Australian courts have the jurisdiction to grant the order, and this is satisfied by being an Australian citizen or ordinarily resident in Australia and living here for 12 months immediately before applying for divorce. If there are children under the age of 18, there must be proper arrangements for their care and welfare, although the divorce can still be granted even if the court is not satisfied of this. And if it is a sole application for divorce, the other spouse must be served unless the court orders otherwise, which only occurs in exceptional circumstances. So depending on the client's situation, they may need to satisfy just 3 or 4 or 5 requirements for their application for divorce to be granted. Okay, so let's look at some hypothetical scenarios and please use the question box to send us your answers. So you are the case manager.
I was
Bridget?
just going to let you know there was a comment.
Sorry.
Oh. Can you hear me now?
I don't know if it's me, but I can't hear you.
I don't know if the audience can hear me, but there's a comment.
Check. Me. Might be just me.
The audience can hear both of us.
Bridget?
I'm just going to send the comment in the chat, but I will read it out. There's a comment from the audience. You can hear me? Okay.
I can hear you.
There's just a comment from an audience member that an affidavit can be substituted with a statutory declaration for name spelling, where when you were explaining earlier that often in Farsi, I think in Darcy, that there can be various spellings translated.
Yeah, so when we're, so if there are any issues with the spelling of names on the marriage certificate, it's not a statutory declaration that has to be prepared. It has to be an affidavit. It's a proper court form that can be downloaded through the court website. That's the form that has to be used and signed before a qualified witness. Just to explain the issue.
Thank you.
Okay, so in this scenario, you are the case manager for Mariam. Mariam tells you that she and her husband, Hassan, are applying for divorce. Mariam does not have family in Australia and is only receiving the partnered parenting payment and family tax benefit for their children aged 3 and 5. She tells you that 12 months ago, Hassan moved into his brother's home, but after 2 months, he moved back into the family home because Mariam could not afford the rent by herself. She says that she has been sleeping in the children's room for the past 10 months. Mariam has found a cheaper property and plans on moving soon. She has begun packing and cannot find her marriage certificate. But she doesn't think this is a problem because she gave a copy to the Department of Home Affairs when they applied for their visa. So she thinks that the court can just check with the department. So what specific legal issues about divorce can you identify that Mariam should be referred for legal advice? I'll get you to use the question box, send us your answers.
I think everybody's pondering the case scenario at the moment.
I know. So what do you think she might need some legal advice about?
Okay, someone's had a go at it. Legal advice around proof of separation for 12 months. And another person has suggested she cannot find her marriage certificate.
Perfect. If we can move on to the next slide, Bridget. So yeah, it's always good to refer clients to get general advice about the process of applying for divorce because it can be quite technical and tricky. And in this scenario, there were two main issues that I identified, which are the two issues everyone seems to have identified, which is awesome. So the first is the separation under the same roof issue. And this would be a scenario where it would be best for the client to get legal assistance with preparing her affidavit about being separated under the same roof to ensure there is enough detail and information to satisfy the court that the parties have been separated for the past 12 months, especially given that Hassan moved back into the property during that separation period. And the second issue is definitely the marriage certificate issue. So the court will not conduct its own investigations into whether an applicant meets the requirements for a divorce. The court will not check in with the Department of Home Affairs to ask for a copy of the marriage certificate. Mariam will need to make all efforts to try to get a copy of the marriage certificate, and this could include requesting access to her immigration file with the department. These are all things that we can advise Mariam on, and depending on her situation, provide some assistance. So let's look at another scenario.
Florence, there's just one issue someone else has raised. I just thought I'd ask you to respond to it before we moved on.
Yeah.
That there would be a need for family law advice for the children as a separate matter.
Yeah, that's a good one. I didn't even put that up there, but true. Children, even if there aren't any current issues, it's always great for parents to get legal advice on. And that's actually something I touch upon, not now during the divorce proceedings, but later when we're talking about recently separated parents. So yes, thank you so much for raising that too. All right, so here we have Adnan, and Adnan arrived in Australia on the 15th of December 2021. He came to Australia with his adult children. He tells you he has been separated from his wife since 2019. He has heard that to apply for divorce in Australia, he only has to be separated for 12 months. So he would like to apply for divorce. He has already translated his marriage certificate for the application. Adnan is not sure where his wife is. When they separated, they were in Turkey, but she applied for a refugee visa to another country. Adnan thinks she might be in Germany as she has family there. So we're going to run a poll.
I'll just launch the last poll.
Okay.
Is this the right poll?
No, so this is a yes or no poll.
Okay.
Can Adnan apply for a divorce now?
We might have to ask people to respond.
In the question box?
Yeah, people are answering this one. So I'm sorry, we've ended up running this poll out of order.
No, that's all good.
So what would you like to do? Should we finish off with this poll?
Let's do, can we wait to do this poll later, Bridget?
I can't, unfortunately, once it's launched, I can't
good.
start
all
it
right.
again later. I'm sorry about that. That's my error. So
No,
everybody sorry for confusing you, audience. Everyone has responded to the poll, so I'll close it off.
Yes. So let's look at the poll then. Are we going to do the poll now?
I could share the responses later.
Perfect. Let's do that.
Okay.
All right, awesome. Thank you.
So sorry, what was the question? We'll ask people to put it in the question box.
Put it in the question box, please. Can Adnan apply for divorce now? So he arrived in Australia on the 15th of December 2021. He has been separated from his wife since 2019. He has heard you only have to be separated for 12 months. So he would like to apply for divorce. Can Adnan apply for divorce now?
There's a bit of a mixture of responses. Yeah. So some people are saying he needs to be here for 12 months. Some people are saying yes. There's a few no's. Someone else has raised the issue about serving his wife. He needs an affidavit for his wife in relation to an unknown address. There's probably more no's than yeses.
More no's?
Yes.
Okay. All right, let's move on to the next slide, Bridget, because the answer is no. So although Adnan has satisfied the 12-month separation period, he does not meet the residence requirement, as someone raised. He has only lived in Australia for 5 months. So he won't be eligible to apply for divorce until after the 15th of December 2022. Okay, next slide. Thinking about Adnan's situation again. What issue can you identify in Adnan's situation that he should be referred for legal advice? And actually, someone has raised the answer that I saw already. So we might just skip to the next slide. And yes, service, definitely. That was the main issue I identified. Not only is Adnan's wife overseas, but it is likely that he will need to ask the court for permission to serve his divorce documents onto his wife in a different way, as he does not know her address or where she's located. And if he doesn't find any way of reaching her, then we might need to look at whether he needs to ask for that requirement to be waived. Okay, so we've come to our first little Q&A session. Using the question box, please send us any questions you have so far. It can be about what I've just spoken about, or maybe something that hasn't come up about applying for divorce that you want to know. Do we have any questions, or should we move on?
Not yet, but there is sometimes a little bit of a delay. I'll just wait just a short time more in case someone is typing.
Mm-hmm.
But it's quite possible that your information is so clear that people don't have any more questions.
I'm hoping that's the reason.
Okay, so we haven't had any more come through.
Okay. Perfect.
The next slide, is it the next poll or no?
Yep. No, this is the right slide. Okay, so now we're looking at responding to a divorce application, and that only applies when a sole application for divorce has been filed. And this is the other side of the divorce process, and it's relatively straightforward, at least for me. So when the respondent spouse is being served with the divorce documents, they'll be asked to sign and return the acknowledgement of service form. The purpose of this form is just to acknowledge that the spouse has received the applicant's divorce document. There is a section on the form where the applicant should indicate what documents are being served onto the respondent spouse, and the respondent should check to make sure that they're actually receiving all of the listed documents and that the documents are complete. Once the documents are served onto the respondent doesn't actually have to do anything. There is no legal obligation to file a response. A response is only necessary where there are mistakes or other incorrect information in the divorce application. The response in that scenario would be for the purposes of correcting such information. Where there are statements in the divorce application that the respondent does not agree with, for example, the arrangements for the children, the response in that scenario would be for the purposes of raising their disagreement and really to create a record of the disagreed statement. And lastly, where there are legal grounds to contest the divorce application. If the respondent spouse files a response, then they must serve their filed document onto the applicant spouse, and they must attend the divorce hearing. So before I go through the grounds on which someone can object to a divorce, I wanted to go through the multiple choice question, which is the one that popped up a little while ago. So I'll get you to just show the results, Bridget.
Sure. I've just brought up the slide that has the question because people completed it a while ago. So
yeah. So
just so that they've got that to read, would you like to read it out for them again, and then I'll share the answers?
Thanks, Bridget. Yes. So in Australia, a spouse can object to a divorce application if A, they do not agree to the divorce, B, they have not finalised their property settlement with the applicant spouse, C, one or more of the divorce requirements have not been satisfied, or D, if any of the above circumstances apply. And the answer is, let's see what everyone thought. That's interesting. 10% do not agree to the divorce. One or more of the divorce requirements is not satisfied, 40%. Any of the above circumstances apply, 50%. That's really interesting. So the answer is actually C. the ability to contest a divorce is centred on technical legal grounds that relate solely to the legal requirements for a divorce order to be made. So that could be the validity of the marriage, the irretrievable breakdown of the marriage, or jurisdiction. Okay. So let's move on to the next slide. Yep. So a common issue that we see that can lead to the dismissal of a divorce application is the date of separation. So being separated, as we discussed, for at least 12 months before applying for divorce is a central requirement for being granted a divorce. And the requirement must be met at the time the application is filed. If a spouse disputes the date of separation and asserts that the true date was less than 12 months, then they should have sufficient evidence to support their asserted date of separation. Okay, now let's look at some hypothetical scenarios as examples. So Nazreen filed a sole application for divorce on the 3rd of May 2022. In the application, she listed the date of separation as 1 May 2021. Her husband, Milad, believes the date of separation is actually 18 June 2021. He recalls having an argument with Nazreen on 1 May 2021, but they did not talk about separating until late May. Milad has photos of a birthday party he and Nazreen attended as a couple on 10 May 2021. Milad also has text messages from Nazreen from another argument in early June 2021, where she says they should separate. Milad left the family home on 18 June 2021 and reported the separation to Centrelink the same day. So I think we're going to run a poll question now about should Milad file a response? Is that right, Bridget?
So that's not a poll, but we'll ask people to respond in the question box.
Perfect. So yes or no, should Milad file a response?
People are saying yes.
Cool. Great.
And there's just a question that's come up too. It means even property division can be completed while they're still separated.
I might leave that till later to talk about property stuff. I might just make a note of that.
Sure. So everyone has responded yes to that question.
Okay. Perfect. And so yes is the answer. In this scenario, Milad has a legally valid reason to file a response asking for Nazreen's divorce application to be dismissed. If the court finds that the true date of separation is 1 June 2021 and not 1 May 2021, then the application will be dismissed because it was filed before the 12-month separation period had lapsed. Although the application would be dismissed, it does not prevent Nazreen from reapplying for divorce after the 18th of June, and it's unlikely Milad will have a valid reason to object to the divorce on that occasion. So what if the scenario was slightly different? Let's look at the next slide.
Just got a question about service, so let me know, service of an application, so let me know when you'd like me to read that out.
Yeah, we'll have another little Q&A session in a couple of slides, and I might just answer those questions then. Okay, so here we have Abbas, who filed a sole application for divorce on the 10th of May 2022, and the date of separation he listed on the application is 16 March 2021. Manar believes the date of separation is actually 29 April 2021. She says that this is the date Abbas moved out unexpectedly. He had been acting differently since about mid-March and sleeping on the sofa, but there was no talk about separation. So should Manar file a response?
So we've had a no so far. couple of no's. So far, everyone's saying no.
No? Okay, all right. So the answer is really, it's up to Manar, but I would say yes. I mean, there is still a dispute about the true date of separation, but in Manar's response, she wouldn't request that the application be dismissed. And this is because on either date, the spouses have been separated for more than 12 months at the time the application was made. So Abbas's application for divorce is still a valid application. So Manar can simply file a response indicating she does not agree with a statement in Abbas's divorce application, which is the question about, the date of separation, and she would list the date she asserts to be correct to have a record of the disputed date. Now let's look at one more scenario before we move on. So here we have Samira, and Samira filed a sole application for divorce on the 14th of May, 2022. She listed the date of separation as 8 January 2021. Her husband Hadi agrees that he and Samira stopped living together since 8 January 2021. He does not consider the marriage over and has continued to try to reconcile with Samira. Hadi has asked his brother-in-law to help communicate with Samira. He previously asked a member of the community to try and mediate the situation, but Samira refused to meet with Hadi. There are no other statements Hadi disagrees with in the application. So should Hadi file a response, yes or no?
We're getting a mixed response. There's a no, a few yeses. More yeses than no's.
Interesting. So the answer is actually no. So this is because the dispute is not actually about the date of separation, which is a central requirement for a divorce to be granted, but rather Hadi's disagreement to the divorce itself. So if we remember what the date of separation means, it's when one spouse considered the marriage to be over and in some way communicated that to the other spouse. So in this situation, Samira has very clearly communicated that she considers the marriage to be over. And so the date of separation is the date, and Hadi does not disagree that they haven't been living together since the 8th of January. So in fact, there are no statements Hadi disagrees with in the application. He's not saying that he and Samira have not been separated for more than 12 months. So Hadi doesn't have a legally valid reason to object to the divorce and ask that the application to be dismissed. There is also no incorrect information in the application. So in that situation, Hadi does not need to file a response. And he really shouldn't file a response because, there's no point. What's he going to respond? All right, so let's move on to the next slide. And so apart from the grounds for objecting to a divorce, which my clients, very frequently ask about when they're the respondent, most clients who are the respondent in divorce proceedings often ask whether they must sign any documents for the divorce to be granted or whether they have to pay any court fees. And the answer to both is no. They don't need to sign any form saying I agree to the divorce. The court doesn't need their consent to be able to grant the divorce. Ideally, when the respondent spouse is served the divorce documents, they should sign and return the acknowledgement of service form. Signing the form does not mean they agree to the divorce being granted or prevent them from filing a response. It simply acknowledges that they have received the documents listed on the form. That's why it's important to check as well that they have received all the forms listed on that form. So even if a spouse does not sign the acknowledgement form, as long as there is evidence that they have been served with the documents, the court can proceed with the divorce. The other frequently asked question I hear is whether the court can still grant the divorce even if the respondent spouse does not attend the hearing. And the answer to that is yes, they will. They can and they will. If all the other legal requirements are met, they can and they will. Okay, so this is, we're going to move on to the next slide. And this is a brief overview of what the divorce process looks like after an application is filed. I'm not sure if the font is too small. I'm sorry if it is. But at the top, we can see that, you know, when they file for divorce, they have the option of filing a joint application, which is where both spouses sign the application, or a sole application for divorce. And that's where only one spouse signs the application for divorce. You'll see that the service requirements only apply to sole applications. They don't apply to joint applications because both spouses are aware of the court proceeding. They've both either prepared or at least signed the divorce application. So the next step in a joint application process is the divorce hearing. Whereas with sole applications, there are a few more steps in the process. They have to serve their spouse, and they have to do that at least 28 days before the divorce hearing if their spouse lives in Australia, or at least 42 days before the divorce hearing if their spouse is overseas. And then the spouse has the option to respond to the divorce application. Once the court, so the next step would be at the divorce hearing, and at the divorce hearing, if there are any issues or the court requires further evidence to be filed to be satisfied of any of the divorce requirements, then the case will be adjourned. And that means another hearing date is given to allow the applicant to file their further evidence. And often the court will give them enough time to be able to prepare their further evidence. Once the court grants the divorce, it takes 1 month and 1 day for the order to become final and effective. And once the divorce becomes final, clients are no longer legally married to their spouse, and they can remarry if they choose. Okay, so we've come to our next Q&A session. So I'll answer some of the questions that have popped up before, and you can use the question box to send through more questions. And if we don't have time now, we'll have more time later to answer them. So that question about property settlement, Bridget. So was that essentially, when can a property settlement be started or be done?
I might just ask the audience member to perhaps, I don't quite understand the question, if they wouldn't mind, and I don't recall at what point in your slides the question was entered. So if you wouldn't mind perhaps asking it again in a slightly different way, I'll just move on to the next question about service. I know my ex-partner's address. He lives with his father. If I ask a person to serve my ex-partner and he is not willing to see the person serving, is the service valid?
So this is a common thing that happens. You know, the spouses try to avoid service, or they don't want to take the documents. In order for service to be effected, done properly, the person who's trying to hand the documents to the spouse, they need to see them. They need to make sure that they're actually there. They can't just turn up to the house and leave the documents at the door, because they haven't made an attempt to personally serve the spouse. So if they see them through the window, for example, and they say, I'm just trying to give you the divorce documents filed by, Samira. It's in court on the 20th of June. And they're like, no. As long as they then leave them at the door saying, okay, I'm leaving them here for you, and then later fill in, there's a form that the person serving has to fill in. As long as they write what happened in that form, tick the right boxes saying, I tried, I attempted to serve, I left them at their feet, kind of on the ground near the spouse, that's fine. So if the respondent spouse doesn't take the documents, that's still okay, as long as the person serving them has physically seen the spouse, has told them what the documents are, and has left the documents in the spouse's presence. And that's enough. Then there's a form that needs to be filled in as evidence.
Thank you, Florence. I've just had another look at the question. I think the initial question about property settlement is, even if a property settlement hasn't been completed, spouses can still be separated.
Yeah, and that's right. So property settlements are often, only where there are major assets, superannuation, savings, land, or houses, those types of things. They can do a property settlement at any time after they separate. Once they get divorced, they have 12 months from the date of divorce to do a property settlement if necessary and if they want to. If they don't do it, then there's some problems, like if they don't do it within the 12 months. But they don't have to do a property settlement to apply for divorce, and it doesn't have to be completed to apply for divorce. Did I explain myself, or did I confuse you a little? Did that answer the question, whoever asked the question or made the statement?
Oh, yes. So they have clarified. There's just a little bit of a delay sometimes with these questions. Yeah, the question was, can divorce occur before property settlement?
Yes, definitely. Yeah.
Okay. So there's a question about where you can apply for sole parent support because the ex-partner is not contributing.
Okay, so that, when they say, so the key terms I picked up was sole parent and partner not contributing. And so,
sorry, I paraphrase there, because the ex-partner doesn't take any parenting responsibility.
Okay, so I think, if we're talking about financial support about children, ordinarily we're talking about child support. This webinar isn't focused on child support, but just generally, each parent has an ongoing legal obligation to financially provide support for minor children. And so when parents separate, either parent can apply to the child support agency, it's Services Australia, for a child support assessment to be conducted to assess how much child support each parent has to pay. And so the child support formula is based on the percentage of care a parent provides to a child, and that's calculated per night, not daytime. So if there's no overnight time, it's not counted as care. They look at the parent's financial circumstances, so their income and their assets, to assess how much money the parent legally needs to provide to a child. And that's all the parent needs to provide. If they want to pay more, they can do that by private agreement that can be registered with the child support agency if they like. And I think that's enough for child support.
So I think that's everything, all the questions.
Perfect.
At the moment, so we can move on.
Perfect. Okay, so let's move on to the practical issues in divorce proceedings. Now, one of the biggest practical issues our clients face in the divorce process is their ability to navigate online systems. And I consider this to be one of the biggest issues, because applications for divorce, responses, and any other documents that must be filed are filed through the court's online system called the Commonwealth Court Portal. And that's just a little snapshot of what that website looks like. The portal allows you to save the divorce application as you go and return to finish it later. But once started, the application must be submitted within 90 days. Otherwise, it will automatically be deleted and you'll need to start the application again. One of the changes that was implemented a few years ago is that divorce orders are no longer automatically posted to the applicant or applicants if it was a joint application. Instead, the divorce order and certificate is now available to download from the court portal after the divorce becomes final. Okay, so another practical issue is the client's financial ability to apply for divorce. There is a filing fee that must be paid to the court online at the time the application is filed. The filing fee that must be paid has to be paid using a credit card or a debit card. And currently the full filing fee is $940. Most of our clients will be eligible for the reduced fee, which is currently $310. But even with the reduced fee, some clients will need to save up before they can pay this amount, which means they are not able to file their application for divorce until they can afford to pay the filing fee. And the last practical issue that commonly impacts refugee clients are their technological ability and their English skills. So divorce hearings are now solely conducted by telephone. The court emails parties in divorce proceedings the dial-in details a few days to about a week before the divorce hearing for them to attend the hearing by telephone. Often clients will need a friend to help them dial into the call and learn how to mute and unmute themselves. Another change implemented by the court a few years ago is that they no longer arrange interpreters for divorce proceedings. However, clients can have a relative, a friend, or other support person attend the hearing with them to act as an interpreter for them, and they don't need the court's permission to have this type of support. So let's look at some hypothetical scenarios as examples, and we'll get you to use the question box to send us your answers.
I'll just let you know there are a couple of questions about eligibility for reduced fees.
Yeah. Should we do that?
We can address. Yeah, I just thought I'd check with you if you wanted to address it before we moved on, but we will definitely have time at the end. So sorry for interrupting.
No, don't be sorry. I'm just trying to think. Should I do it now? Should let's just do it now, just in case. So what was the questions around eligibility?
Just about how do you find out if you're eligible for a reduced fee? I think you said most of our clients would be eligible. Yeah. So what are the criteria to be able to pay the reduced fee rather than the full fee?
So there's two different situations. So one is the general reduced fee, and that applies to people who have a healthcare card, a Centrelink card, if they're receiving the seniors pension or they have a seniors pension card. And then the other one is financial hardship. So if the client doesn't have any of the above documents I mentioned, if they would experience financial hardship, if they were required to pay the $940, then they would be eligible for the reduced fee. When I say they would be eligible, the court has specific guidelines about how much income or how much money left over the applicant's allowed to have before the court will say, yes, you are granted the reduced fee. So if you go onto the family court website, they have those guidelines about financial hardship. But like I mentioned, most of the clients, if not all of the clients that I have helped with their divorce application will have satisfied the general reduced fee eligibility criteria.
Thank you, Florence.
No worries. Okay. All right. So if If we're thinking about Abdul, in this scenario, Abdul is making a sole application for divorce. With the help of a friend, Abdul created a Commonwealth Court portal account. Abdul thinks his friend started with the application for divorce. Abdul thinks his friend started the application for divorce because his friend was typing things down, but Abdul cannot find the application on the portal. Abdul's friend is very unwell and he's unable to continue to help Abdul with his application. Abdul does not know what to do, he cannot read English, and he only understands a little English if spoken slowly. So what practical issues do you see in Abdul's situation that he will need help to overcome? Let's put our answers in the question box.
So we've got some answers coming through: lack of English proficiency, support person, translation services, writing and or form completion support.
Yeah.
Need an interpreter that can help him.
Yeah, definitely. So I'm loving all these answers because when I was thinking about this, I think I put them under three main categories. And so the first that I identified that Abdul would need to help to overcome is definitely navigating the online system to complete and file his application for divorce. So it's likely that he would also need help accessing and navigating his emails to find the dial-in details for the divorce hearing. And so attending the divorce hearing by telephone was the other issue that I identified, practically calling into it, but having someone attend as well, which made me think of the third one, which was understanding what is happening in court during the hearing because of his low proficiency. So having a support person there, having someone interpret for him, that would be wonderful. And although these issues and the assistance he wants relates to legal process, it's non-legal support that can be provided to Abdul to overcome these practical issues. Okay. So if we move on to practical issues for recently separated clients, when I was thinking about this topic, I narrowed it down to three broad areas. The first area is accommodation. And often the reason why spouses don't physically separate, or sometimes don't separate at all, is because of the uncertainty and financial inability in finding alternate accommodation. Now, practical issues around accommodation include not only looking for private rental properties, but completing rental applications, applications for rent start, bond loans, for rent assist, for housing, and then of course dealing with the current tenancy if they were included as a tenant on the agreement with their spouse. The second area that I identify is Centrelink. So separation is a change in circumstances that must be reported to Centrelink if the client is receiving a Centrelink benefit. Centrelink recipients have an ongoing obligation to report changes in their situation within 14 days of the change occurring to ensure that they are assessed correctly for their payment. Often I have clients ask me about an official separation, and there's no such thing as an official separation. They don't need a document or anything like that. But what they should be doing is contacting Centrelink if they're receiving the Centrelink benefit and reporting the separation to them. And that's a formal process. So clients will need to complete and submit the Centrelink separation details form, notifying Centrelink of their separation. And if a client is separated under the same roof, they must still report the separation to Centrelink. And in that situation, they would complete the separation details form as well as the relationship details separated under one roof form. And the third area that I identified was arrangements for the care of children after separation. And so that was something that someone raised earlier in the webinar. So spouses can informally negotiate between themselves and reach an agreement about who the children will live with and the time they will spend with the other parent. If spouses can't communicate effectively or they can't agree on the arrangements, then often they will need to go through a mediation first to try to resolve their parenting dispute. And while mediation and negotiations aim to reach an agreement, it's often beneficial for spouses to undertake parenting after separation courses to help them transition into this new co-parenting relationship, and even family counselling to develop communication tools and often to mend the relationship between the spouses so that they can co-parent in a positive way. So how can you best support your client through these processes? So firstly, I would say that early referrals for legal advice, that's probably the most important one. Early intervention reduces the likelihood of problems escalating, and it's better to take a proactive approach than a reactive approach in these types of matters. You don't have to wait for a client to separate to refer them for advice. I often speak to clients who are thinking about separation, so the advice session focuses on these practical issues that we've spoken about and giving them general advice about the law. Referring a client who is thinking about separation or shortly after they tell you about their separation works to ensure they have a better understanding of the law, and it reduces the risk of them relying on inaccurate or misinformation. Inaccurate information or misinformation. And they also know who to contact if any issues arise, if they've already spoken to us before. So like I've mentioned, you can refer clients at any stage of their process to get legal advice. The divorce matters, the issues you should be looking out for include marriages that are less than 2 years, separations under the same roof, disagreements on the date of separation listed on the divorce application, or if there are any incorrect details on the divorce application, not having a copy of the marriage certificate, misspelt or incorrect details on a marriage certificate, not knowing the other spouse's address or where the other spouse is a missing person, and matters where there are current AVOs in place, especially if the AVO has a no contact order. Now, when referring clients for advice for family law issues, remember to provide the other spouse's full name and date of birth. This is because we conduct checks just to make sure that we haven't previously spoken to the other person, and the Refugee Service is a very small team, so we really appreciate knowing that beforehand. It's also helpful to provide the name and dates of birth of any children of the relationship, and you should indicate whether it's safe to call the client if they have not separated yet or they're separated under the same roof. Now, with divorce proceedings, if it fits within your work policies, of course, and you feel comfortable doing this, clients can be assisted with the clerical tasks such as creating their Commonwealth Court portal account to apply for divorce, helping them write in their answers in the online application. If they're the respondent in the proceedings, helping them contact the court, it's called the National Inquiry Centre, to request their client ID number so that they can link their court portal account with the court case, helping the client dial into their divorce hearing and acting as the client support person during the hearing, and possibly even helping them with interpreting if that's possible. So with recently separated clients, we discussed earlier the practical issues they face and the assistance they need. So I just wanted to highlight two main things. Firstly, helping clients report the separation to Centrelink. So when they apply for divorce, they need to provide an exact date of separation. So reporting the date of separation to Centrelink means that there's a record of it somewhere where they can later contact Centrelink and get that date if they have forgotten the exact date. You can also ask them to take a note of it and write it down somewhere they can easily access when they become eligible to apply for divorce. Secondly, if there are minor children of the relationship, talk to your clients about parenting after separation courses, even if there are no current parenting disputes. Co-parenting is hard and it gets trickier as children grow up and as parents move on with their lives and into new relationships. If your client has communication or trust problems with their former spouse, then talk to them about family counselling as well. It's really about trying to prevent legal issues from escalating and clients from feeling frustrated or helpless. All right, so now I want to look at some hypothetical scenarios and get you to use your question box to send us your answers. I want to brainstorm what type of non-legal assistance the client can be provided with in these scenarios. Okay, so during an appointment, Mina mentions to you that she's thinking about separating from her husband. Mina and her husband have 3 children aged 11, 9, and 6. Mina has started looking for private rental properties but cannot afford to move out yet. She has no savings and every property she has seen so far requires a bond of $2,000. Mina has been told by her friends that she cannot apply for divorce until she has physically separated from her husband. They also tell her that without any court orders in place about the arrangements for the children, her husband can take the children from her if he decides to do this. What tasks or types of things could you do to help me in this situation? What are we thinking?
Just giving people a little bit of time.
And there's quite a lot to unpack on this one, I think.
Yeah. Arrange an appointment for legal aid.
Yep, that's great. Get early advice.
SUOR application. So a separated under one roof application.
Yep. So at the moment she's thinking about separating, but if she does, yep, definitely.
Husband cannot take the children.
Yep, so that would definitely be something that she would be getting advice on. And the advice would be very unlikely.
And inform her about the 12-month separation requirement. Does not have to be physically in 2 spaces.
Yeah, so that would be part of the legal advice that we would be providing her about, when she can apply for divorce and, the meaning of separation and all of that. Yeah, definitely.
Register when separation occurs and legal aid appointment.
Yeah, perfect. The other thing that I, sort of non-legal assistant is she's talking about a bond. She's talking about $2,000 worth of bond. She can't afford that at this point in time. So
housing, someone's mentioned just
yeah,
now.
definitely housing. That's the one. So looking at housing application, long waiting periods we're looking at. So it could be private rental applications, could be a rent start bond loan because she doesn't have enough money for the bond at this point in time. Yeah.
Someone's just typed that in seconds before you said it.
Perfect. I'm glad we're all on the same wavelength. Yeah.
And then, there's a question, I think, about the scenario, so I'll just ask it. Is there domestic and family violence?
That's definitely a question that we should be asking about, just to assess, what type of assistance she needs. Does she need safety planning? How urgent? Does she need urgent accommodation? So that is something that you should always be checking with your clients to see if there has been a history of family violence, if there's currently family violence. Yeah. Okay, so let's move on to the next scenario. So you see Mina again a few months later, and this time, she tells you that she has separated. She tells you that her application for a Rent Start bond loan was granted, so she moved into a new house with the children last weekend. Mina mentions that it's frustrating talking to her husband because they can't agree on anything. So you ask her about the children, and she says that so far, that is the only thing they seem to be agreeing on. Her husband works full-time and sees the children about every fortnight, sometimes less. Every time he collects the children, Mina and her husband argue in front of them. Mina doesn't like this happening, and it was one of the reasons she separated from her husband in the first place. So what types of things could you do to help Mina's situation?
Someone has suggested a parenting after separation course and consideration for the children's well-being, so referrals around that.
Perfect. Yeah, that's exactly what I was thinking. Get them into some parenting after separation courses, possibly even family counselling if they can't seem to communicate with one another after they do the courses as well.
Yeah, another audience member has suggested family conciliation or mediation. Parenting course involves third party to pick up the children. Arrange for a different place for changeover, both along the same
perfect.
lines.
Yeah, and that's really good sort of practical things that they could do to try to reduce that sort of hostility. The other thing that I just thought of, she moved into a new house. Before she had said that she didn't have a lot of money, she didn't have any savings, so she might need some help with getting some home goods, some appliances. And I know that Good Shepherd, they offer some sort of no interest loans and support around that. So that could be something that you could look into and see if you could provide those details to Mina to help her create her little house with the kids. Okay, so that brings us to the end of what I wanted to talk about during this webinar. If you would like to refer a client to the Refugee service, you can give us a call on 8713-6725, or you can send us a referral email to our email address, refugeeservice@legalaid.nsw.gov.au. If you would like us to conduct a community legal education webinar for any groups you deliver or staff, feel free to contact us as well. So I'll leave it to you guys to send through some questions if you have any final questions.
There was one. I'm just scrolling back to it. About you mentioned that the court no longer organises interpreters. So the question was, can a client arrange their own interpreter then?
Yeah, so the client can arrange their own interpreter. That would mean that they would contact, an interpreting service. They would cover those costs. They would arrange to meet with the interpreter, have the interpreter with them when they dial into the hearing. And so often clients don't have the capacity to do that or cover their own costs. So if they have a friend, relative support person who could act as an interpreter, they usually go with that option.
There's another question. Is there a portal for applying sole parenting like there is for divorce?
Okay. So I'm going to take that to mean to apply for parenting orders, to start some court proceedings around a parenting matter. And yes, so the Commonwealth Court portal is the court portal to start any type of application family law related application with the family law court. So that would be an initiating application seeking some parenting orders about who the child will live with, what time they'll be spending with the other parent. It could include an order for what's called sole parental responsibility, which is the decision-making power parents have, and for a child to live with the parent. And so often people call that sole custody. So that can definitely be lodged through the Commonwealth Court portal.
There was just one other comment in relation to one of the scenarios that if there were domestic and family violence, they could help support a client by helping them to apply for the Start Safely program.
Yeah, and thank you so much for raising that, because there are, lots of different support initiatives and programs in the Start Safely. That's an excellent one. So that's why it's always helpful to really ask clients different questions. And sometimes I ask clients and they say, no, there isn't any family violence. So and I'm sure everyone does this, you ask more nuanced questions to assess whether or not there has been or is a risk of family violence.
There's just a thank you and compliments. No further questions for me. Thank you for your time and for such an engaging webinar. It was nice to participate in the learning as opposed to having to sit and listen.
Oh, thank you. I'm so happy to hear that, because that's what I hope all my webinars achieve. So I'm very happy to hear that. Thank you so much.
Yeah, lots of thank yous, very informative. People thanking you for the information.
Perfect. I do want to take the time to let you know that Bridget and the wonderful CLE team will be emailing out some fact sheets that I prepared about different divorce topics. So funnily enough, I have getting married in Australia as the first one, and then I have separation and divorce, applying for divorce, and responding to a divorce. And so these fact sheets have a lot of detailed information, a lot that we covered today, and that will be sent out to you after this webinar.
And we'll just mention too that we do, there will be a survey in an email you'll receive about an hour after the webinar time ends. And we really appreciate your feedback, such as suggestions for other legal topics you would like us to run webinars on. So if there's something that we haven't covered and it's a burning issue for you and your clients, then consider completing the survey, because we try and respond to those suggestions and we always welcome them. So I think that's it for the questions. Lots of thank yous. People really enjoyed it. Thank you to our audience for joining us. And thank you to Florence for such a wonderful presentation.
Thank you. And thank you, Bridget, for being here with me and helping me through this.
It's my pleasure. We'll end the webinar now. Thanks, everybody.